Hello there, and thank you for taking time to join us again today for another exciting talking point. Now, if you consider yourself a future millionaire or someone who's just always hungry to learn more and grow more, then this is the correct channel for you. At Wealth Masters TV, we focus on educating you to become highly skilled property investors. But the best part is that we also teach you how to do it using other people's time, money, and skills. Now, speaking of skills, today's topic is relating to your estate planning and in particular your will. So to talk a little bit more on this topic, please welcome our legal expert, Marishka van Zyl. Marishka, thanks so much for joining us.
Thank you. Glad to be back, Damien.
Fantastic. Now, Marishka, can you just tell us, the people that are viewing us at home, why is it important for someone to have a will in place?
Well, the most important reason is if you have a will, you can choose how to divide your assets. Now, secondly, even when all assets are in trust, you want to include clauses residing over the loan accounts, as well as who must replace you as a trustee.
So speaking of replacement, what happens then in the estate in the event of someone passing without a valid will in place?
Your estate will be divided according to the Intestate Act, where the rules of law will be used to decide who gets what from the deceased estate. And in case of a marriage in community of property, one half of the estate belongs to the surviving spouse. And although it forms part of the joint estate, this will not devolve according to the rules of interstate succession. But certain beneficiaries will have preference, like the spouse and the children.
Now, in the article that you wrote last week, you mentioned that there must be a will in writing. So why is that, and what happens in the event of someone not having a physical copy of their will?
Well, a written will means that this must be typed and printed out or be handwritten. When another person writes the will for you in their handwriting, they must not be mentioned as a beneficiary as they will be excluded. Now, the testator must sign each page, and on the last page, the date is very important, as this will determine whether this is the latest will. The master only accepts original wills, and if it is lost or the remaining family only have a copy, they will have to turn to the court proceedings, and this is very expensive.
Now, in terms of keeping that will, where is it kept? And is it wise to sort of keep it in your top drawer, or are there certain requirements in place for where that will is stored?
Keep your will in a safe place. When it's kept in the top drawer, it may get lost. So it is recommended to keep a will in a fireproof safe.
Perfect. Now, you mentioned the importance of the people who sign your will. So you mentioned that if someone is writing it on your behalf, they can't be a beneficiary. So especially those people who also then witness your will. So can you take us then through that process of what the restrictions are for who can sign and who can act on your behalf?
Well, this rule applies to a witness as well. So when a witness signs a will, they do not even have to know what the contents of the will is. Their role is to identify the testator. So the testator or testatrix must sign in the presence of two witnesses, and the minimum age of a witness is 14 years.
And Mariska, what is the role of the executor in a will?
Well, the executor you can appoint in your will, and the executor or executrix is the person appointed to administer the deceased estate. So they will collect all information, such as the assets and liabilities, and they will make sure that the assets are distributed correctly, liabilities are paid, and that the deceased estate is eventually finalized.
And then, Mariska, the last question from my side, you mentioned that a witness can be 14 years or older. So can children under the age of 18 inherit from your will? And if not, is there a way around this?
So they cannot inherit, they will not receive the assets or the cash. So any assets that you bequeath to them will be sold, and the money will be kept in the guardian's fund, where that applicant must claim maintenance or allowance. So yes, there is a way around it. You can bequeath the assets to your inter vivos trust, where the minor children is a beneficiary, or you can make a provision in the will and draft a testamentary trust, and this trust will be registered when you are deceased.
Fantastic. Marishka, thank you so much for joining us today. We kept it short and sweet because I think it's quite a lot of information to take in. So thank you for sharing that knowledge. And if people want to get in touch with you, how can they do so?
Well, they can contact Wealth Masters to get my details, or they can send an email to Treasury Trust Services.
Perfect. Thank you so much. We'll be sure to link all of those links and details below. Now, if you want to learn more about the Wealth Mastery way of investing in property, which is aimed at helping ordinary South Africans create and protect their wealth, then please register for our free online training taking place this weekend. The link is in the description below, so make sure you don't miss out. Thank you so much for joining us again today. We will see you again next week, and we look forward to learning and growing together. Bye-bye.